isn't too remote. It's up to the defendant then at that stage to introduce a defence. They remember what the goal of a defence is. The reason why a defendant is going to introduce a defence into an action is so that he can deny, refute, or negate liability. That's what the defendant's goal will be in introducing a defence. It's going to minimise their level of exposure or minimise their level of liability. The defendant will be arguing, I'm not liable at all, but there might be a finding of some liability there. So we started looking at some of the defences last week, and particularly we looked at this defence last week, this defence of contributory negligence. Now, this defence of contributory negligence is written into the legislation. So Section 34, the Civil Liability Act 1961, actually deals with this defence. So it's not plucked from the air, it's not detailed in the Constitution or EU law or anything like that, but it is outlined within our legislation. And the idea of contributory negligence is that where a claimant is found to be responsible in some way for their own injuries, there will be an apportionment of damages. So in other words, the award of damages that they'll receive is going to be reduced. And how will the court reduce it? The court will reduce this level of damages depending upon the degrees of fault of both the plaintiff and the defendant. So the court is going to have to actually work out and see what's the level of fault by each of the parties, okay? How much damage can be attributable to the plaintiff and how much damage can actually be attributable to the defendant. If the court finds themselves in a situation where they're actually unable to apportion the fault, they'll have to do so on an equal basis, okay? So it'll be, as the court thinks, just and equitable having regard to the degrees of fault of the parties. And as I was saying there, ladies and gentlemen, that if the court is unable to determine the relative fault of the parties, liability is going to be apportioned on an equal basis. Okay, so moving on here, folks, and we looked at a couple of these cases last week. We looked at O'Leary and O'Connell last week, and we also looked at Carroll and Clare County Council. So I'll just move on now and look at it. So failure to wear a seatbelt. Okay, so we'll pick up from here and talk about the failure to wear a seatbelt and what has the law to say about that? What does the law think about that and contributory negligence? Okay, well, with respect to that, the court says now, sorry, I'm still people coming into the waiting room and I'm just letting them in. Okay, so failure to wear a seatbelt, right? The law treats this as being contributory negligence. So nowadays, where somebody doesn't wear a seatbelt, no special evidence is required to prove contributory negligence or any of that. In Hamill and Oliver, this is a Supreme Court decision. And as you know from your study of the first topic, the study of the Irish legal system, we have a hierarchy of courts, and our hierarchy of courts means that the Supreme Court is actually sitting at the top. And the Supreme Court said in Hamill and Oliver that the failure to wear a seatbelt is contributory negligence, that there is no special evidence, there's no need for any special evidence to be required to show that wearing of seatbelts prevented or reduced injuries. So no special evidence is required for that. Now, okay, in fairness to the Supreme Court, in fairness to what the Supreme Court said here, they did recognise that there are excusing circumstances, that sometimes somebody won't actually be able to wear a seatbelt for excusing circumstances, and this could be because of post-operative convalescence, it could be pregnancy or whatever. It'll depend upon the circumstances of the case. But in Hamill and Oliver, the Irish Supreme Court has said that a driver or passenger in a motor vehicle who fails to wear an available seatbelt is guilty of contributory negligence. So it's automatically regarded now as being contributory negligence, as being the failure to wear a seatbelt. So that principle was confirmed in Hamill and Oliver. So what happens if there is a failure to wear a seatbelt? What is the level of fault, or how much will the damages be reduced by if somebody fails to wear a seatbelt? So in Sinnott and Quinsworth, this case involved the plaintiff, who was a passenger in a car owned by the defendant, was injured when there was a collision between the car and the bus. And evidence showed that the plaintiff's injuries would have been much less if the plaintiff had actually worn a seatbelt. So the plaintiff's injuries were reduced by 15% for the failure to wear a seatbelt. So nowadays, or since those cases, generally speaking, a 15% reduction is made for front seat passengers not wearing a seatbelt. Okay, so when you're not wearing a seatbelt, a 15% reduction. That's just general. It can always be changed. It'll depend on the circumstance of the case, which you'll see very shortly now in the case where the damages were reduced by a different amount. So what happened in McGowran and Reynolds? And the court reduced the damages here where he had been thrown violently against the side of a van in a manner that would have been reduced, or his injuries would have been minimized to a significant extent if this plaintiff had actually been wearing a seatbelt at the time. Now, but what's more interesting, guys, is the case of O'Sullivan and Ryan. This case. A 40% reduction was made in the, sorry, not 40%, sorry, I'm reading wrong. A 25% reduction was made for failure by a member of An Garda Síochána to wear a seatbelt. The facts of this case of O'Sullivan and Ryan were that you had an off-duty Garda. He was after attending a social function and he travelled as a front seat passenger in a car that lost control and struck the front of a tree. So our plaintiff in this case, who was the off-duty Garda, he admitted he hadn't fastened his seatbelt at the time of the collision, and he was thrown forward forcefully in the collision. So the judge, in deciding this case, the judge reduced the damages by 25%, saying that there was no forgiveness for a responsible and an experienced man such as the plaintiff for failure to wear a seatbelt. So the court reduced the damages by a full 25%, given the experiences and given the responsibility of the plaintiff. The damages were reduced by 25%. So there was contributory negligence here, and the court reduced the damages by 25%. So there are seatbelt cases. So you can see there, ladies and gentlemen, that it's when there has been a failure to wear the seatbelt, the court tends to reduce the damages by 15% and regards it as being contributory negligence when there has been a failure to wear the seatbelt. Other cases involving contributory negligence includes this case of O'Sullivan and Dwyer. Here you had a reduction of 40% made in the level of damages to the plaintiff, because the plaintiff, when he was working for the defendant, he fell off a flat roof that had been inadequately protected. There wasn't enough safeguards on the roof. So why was there a reduction in the level of damages that the plaintiff recovered? And the deduction was made here on the basis that the plaintiff should have been equally aware of the danger in the circumstances. So he should have been aware of the danger in the circumstances, and the court took that into consideration. Okay. So Kieran, is it? Kieran McGovern? Can you hear us, Kieran? Kieran, you put a question in the chat there, but before I answer the question, I'd just like to clarify it. So, yeah, can you put on your mic, Kieran?
Hello.
Hi, Kieran. Kieran, can I just clarify what you're asking me? Are you asking me about the case of the guard?
Of the guard, yeah.
Yeah.
If he
Okay.
crashed into a tree, who was that was actually suing him?
Okay, so the guard wasn't suing. Sorry, the guard was suing. He was suing for his personal injuries. He wasn't being sued. So essentially, he was suing the driver of the car where he was traveling.
I just wasn't sure if it was like someone's land that might have been suing, or if it was the driver he was suing.
No, the driver of the vehicle. And
Okay.
chances are there was a good few people involved in the case as well. Insurance companies and so forth would have been fighting this type of a case.
Okay, yeah, no, that's fair. That's answer my question.
Okay, perfect. Thanks, Kieran.
Okay.
Okay, so we just finished there talking about O'Sullivan and Dwyer. So there was a reduction in the level of damages the plaintiff received there because he should have been aware of that danger. He was used to it there himself, from his work there as well. What about Devlin and Cassidy? Now, Devlin and Cassidy is involves the parties, and our claimant here, the plaintiff, actually was wearing a seatbelt, but he got into a car um, with a driver who he knew to be intoxicated, and the plaintiff himself here was also intoxicated, and they had a car accident anyway, and both of them were intoxicated. Both plaintiff and defendant were intoxicated. I believe that the driver of the vehicle also was uninsured. So what did the judge find here? And the judge said that on the facts of it, the plaintiff was aware that the driver was intoxicated and unfit to drive. So the plaintiff suffered a reduction in his damages of 50%. So getting into the car, knowing that the driver was drunk, um, was led to a reduction in the damages for the plaintiff in this case. Okay, it didn't matter that the plaintiff was also intoxicated. That didn't affect the finding in this case at all. So you're getting the gist of it, guys, that when it comes to contributory negligence, that there'll be a reduction in the level of damages. And the cases vary. You can have your workplace accident there, to your drivers, to your seatbelts. Okay, and we had the case last week of the Clare County Council not maintaining the roads properly. Okay, now, does age ever come into it? Does your experience ever come into it? Does any of that ever become relevant? So I could just move the slide, sorry. Okay, what about Coffey and Kavanagh, a 2012 decision from the Supreme Court? The plaintiff took this action against her employers because she had an accident at work. She tripped over things that were in her office and she suffered personal injuries. And she took a legal action against her employers. She claimed that they were negligent in that they had failed to provide a safe place of work and that they had failed to provide a safe system of work for her. However, the court found that she was actually contributory negligent because of the manner in which she kept her office. I think part of her remit involved packaging and making up packages for clients and so forth. And she had them all spread around her in the office and she had no organized system. So she kept a very untidy and a very cluttered office herself. And the court said that she was contributory negligent, given that she had a responsibility to herself to keep her desk and the area around it tidy. So contributory negligence can be found in a wide variety of situations. So there's a duty there as well to keep the property safe. And I can see that people are putting messages in the chat. Did the plaintiff win the case, or was there a deduction? In the case of Coffey and Kavanagh, I would have to check it out again for you to tell you exactly what the deduction was in that case. But I can find that out for you after class. Okay, so then what about the age, experiences, and qualifications? Or do they ever become relevant when it comes to contributory negligence? This issue was explored in the case of McKeever and Dundalk Line Company. The employee in the case was 15 years of age and he was told to remove rust from a machine. Now, at no stage was he told of the risks that came with cleaning rust. And of course, there was an accident at work, and the case went to the court and went to the High Court at first instance. And the High Court said, well, the employee was 25% contributory negligent. But more interestingly and more significant is what the Supreme Court said. They said that the employee was not contributory negligent. They said that while an adult would be aware of the risks, a 15-year-old would not. So therefore, what does McKeever case tell us? what are we learning out of the McKeever case? What comes to light after the McKeever case? It is confirming to us, the decision in the McKeever case is confirming to us that that age is relevant, experience and qualifications is all going to be relevant in establishing or checking whether or not there is actually contributory negligence. Similar issues, issues of age, experience and all that of it arises in Doran and Dublin plant hire. So the plaintiff was working on a crowbar on machinery which collapsed, and the plaintiff continued to work with it and he got injured. So what are we dealing with here in Doran? We're dealing with the situation where the plaintiff has been injured with machinery. What is the deal with the machinery, or what is the situation with the machinery? And the machinery was of a new design, and the defendant employer hadn't told the plaintiff how to use this, or he hadn't told the plaintiff to look at the service manual or anything like that. So the employer's negligence was the legal and factual cause here. But liability was assessed at 25%, given that the employee should have known too that he shouldn't have proceeded using this without adequate instruction. Okay, so age, experience, qualifications is factored into it when we are determining contributory liability. Okay, now we'll just look at the next scenario here, folks. It's a very simple scenario that we'll just look at here with regards to tort law and negligence and whether there's any defences. So we have Sally. And Sally has spent an evening with friends at the Student Union bar. She has been drinking, and although she is not drunk, she could be described as merry. Not wishing to walk home in the rain, she accepts a lift with Mike, whom she knows has consumed a considerable amount of alcohol. Sally does not put on her seatbelt, and whilst driving home, unfortunately, the car collides with another vehicle and Sally is rendered paralysed. Right. Okay, so questions here, basic questions here, folks. Who is the correct plaintiff and who is the correct defendant? So in other words, who's going to be taking the legal action here? Who is, if there's going to be legal action, quite possibly, who will be starting off the legal action in this case? So we have two parties, we have Sally and we have Mike. So who do you think is going to be the plaintiff and who will be the defendant? Anyone out there? So who is the correct plaintiff? Who will be the person who will take the legal action? Good, Sally. Okay, don't be shy, guys. Okay, what does the plaintiff need to prove for a successful action in negligence? So what will she need to prove in order for her to have a successful action in negligence? Is there anything she needs to prove? Okay, thank you, Cole. Very good. She'll have to prove duty of care. So the first thing Sally will have to prove in the negligence action is that she will have to prove that Mike owed her a duty of care. Very good. Okay, is there anything else she will need to prove in order to be successful and to make a for the court to make a finding that Mike was negligent? Anything else, ladies and gentlemen, or is that it? Is she home and dry after establishing that Mike owed her a duty of care? Very good, Kieran, that he was the cause of the injury. Fantastic. So that's causation. Now, there is something there between duty and the cause of the injury. So if anyone else, so I'm looking forward to hearing voices, guys. So what comes after the duty of care? So they have to prove that there was a duty of care owed. Proximity, Nicola, will come under the duty of care. They have to prove that there was proximity between the parties to establish the duty of care. So that'll be relevant in the test for establishing whether there was a duty of care owed. Very good, Gabriel. they'll have to prove that there was a breach of the duty of care. Fantastic. And Nicola, gravity of the injury will become very relevant when we're considering the breach of duty. So that is one of the factors that the court can have regard to when they're checking whether there has been a breach of the duty of care. Well done. So now we have Cole saying that we need to establish the duty of care. Gabriel has said that it needs to be established that there was a breach of the duty of care. Kieran has mentioned about causation. And what's the last element then in a negligence action? You have to prove, thank you, Robin and Gabriel, fantastic. You have to prove remoteness. In other words, you have to prove that the injury isn't too remote. In other words, it's not too far away from the injury. Okay, so very good, well done. And are there any defences available to the defendant? In light of what you've just learned in the last few minutes, guys, I'd say it's a safe bet to say that the defendant might plead this defence of contributory negligence. Okay, I would think a safe bet there, folks. What do you reckon? Pure advising Mike. It's quite possible that Mike will try and argue contributory negligence, and then it'll be up for the court to make that finding to decide whether or not there is contributory negligence. Okay, well done, guys. Good work there on attempting those. Thank you. Okay, now the next defence, ladies and gentlemen, that we're looking at, again, we're still looking at defences. Who's going to plead the defence? It'll be the defendant. So the defendant will introduce the defence. Why? The defendant will introduce the defence in order to reduce his level of liability, or to avoid liability, or to minimise the extent of his liability. Okay, so the defence that we're looking at, guys, is called consent. Some places call it waiver. Historically, it was called the voluntary assumption of risk. This defence is found in statute. You know, it's written into law, and it's an absolute defence. Okay, so if it's successfully proven, it means that you know, there's no liability on the part of the defendant if the defendant is able to show that the plaintiff agreed to waive their legal rights. Okay. So when will this defence be used, or how is the defendant going to invoke this defence, or what is the defendant going to argue here? When it comes to this defence, the defendant has to be able to show that before the act, or before the harm complained of, that the plaintiff agreed to waive his rights in respect of it. In other words, that the plaintiff has consented to the harm that's been inflicted on them, that there has been this consent from the plaintiff, that they've consented to the harm that has actually been inflicted on them. It's up to the defendant to prove this defence. So the defendant is going to actually have to prove this defence. And it's important, guys, that if the defendant is relying on this defence, what the courts look out for is that there has been some communication between the parties before the plaintiff can be regarded as having consented, or before the plaintiff can be regarded as having actually waived their legal rights. So the courts, the position was set out in the case of O'Hanlon and ESB, and so what the court looks for there, according to O'Hanlon and ESB, is that they look for some communication between the parties. So some agreement is generally a requirement. And this communication has to be clear. So the communication between the plaintiff and the defendant, it can't have been got through force, or from threat, or through pressure. It must have been given voluntarily. So in other words, the plaintiff must have voluntarily consented to the harm, or voluntarily consulted to the risk. It'll always come down to the circumstances of each individual case, but the defendant is going to have to show that there's been some agreement, or some consent to it. Okay, so case law that has explored this defence. First case we look at here is the case of Regan and the Irish Automobile Club. Our plaintiff in this case, she was injured when she was struck by a racing car. And how did she get struck by a racing car? Well, she was officiating as a flag marshal at a car race. She had signed a consent form relieving the motor club from liability for damage howsoever caused. So she had signed this consent form, but while she was officiating as a flag marshal at a car rally, didn't she get injured? Okay, and she sued. So issue was she entitled to continue running this action, given that she had signed this consent form? Did that consent form stand up? Did it hold? And all the rest of it that had to be explored. And the court said here that the plaintiff was aware of the risks involved and she had waived her legal rights. She had waived her legal rights against the defendants for consideration, and therefore she wasn't entitled to pursue the action. She wasn't entitled to pursue the action because when she was signing this consent form, she was signing this consent form in an exchange for an insurance policy. So she was aware of it. The courts didn't make any finding or have any suggestion that she was unaware of what she was actually signing. So the courts were happy that she understood the nature of what it was that she was signing. Okay, so she lost the case here, guys. She wasn't able to pursue the legal action in the case on grounds that there had been a consent. In Judge and Reap, it's the facts of this case of Judge and Reap are very, very similar to what you had in Devlin and Cassidy. In Judge, the plaintiff consumed a lot of alcohol and then accepted a lift in the car of the defendant, who was also drunk. A collision occurred and the plaintiff was injured. And the court refused to award damages here on the basis of a voluntary assumption of risk and contributory negligence. Okay. So the court found that there had consented and there was contributory negligence here as well. Now, what the situation though when there's no communication or where communication is implied is less clear. What the law is saying that you need to have some communication between the parties, but what if the communication is less clear? And an example of this is McComiskey and McDermott. The plaintiff was the navigator and the defendant was the driver in a rally. Okay, so plaintiff was our navigator and the defendant was the driver. There was a notice in this car, and the notice in this car said that passengers travelled at their own risk. Okay, and was this enough? Did this amount to consent? Did this amount to communication between the parties? So there was an accident, and the issue here was, could the defendant rely on this notice in the car? And the court ruled no, that the defendant could not rely on this in an action by the plaintiff following a crash, because it was already in the car when the defendant bought the car and there had been no further communication between the parties regarding the responsibility of the risk. So the presence of that notice in the car just wasn't enough. That wasn't enough at all. The court said here in McComiskey and McDermott that there had to be some further communication between the parties regarding the allocation of risk. So that notice in the car just wasn't going to be enough in order to exonerate the defendant from liability. And the case of Anderson and Cook involves something a little bit similar. The parties in this case, what happened here was you had the parties in the case, and the plaintiff was injured following a road traffic accident, and the parties actually had a plan. They were going to drive at 120 miles per hour and they were going to post the photograph to the internet at the time. They're going to put it on social media, whatever platforms of social media would have existed at the time. So when the plaintiff was taking the legal action against the defendant's argument said that, well, we had this plan. It was our plan and the plaintiff was fully involved in it. He fully agreed to it, and that the plaintiff wanted to be part of this, to drive at the speed with the defendant, and that the defendant they'd post the photograph to the internet. And the court found here that there was no waiver found to exist in the case. So we're only looking at this case from the point of view of whether or not a waiver existed. And what the court reasoned here, the court ruled here, is that there was no waiver and no agreement between the parties here. No agreement between the parties here in this case. All right, so no waiver there. So what are we learning about waiver? And what we're learning there about waiver, guys, is that the law requires that there has to actually be some communication between the parties in order for it actually to be a valid waiver or to actually be a proper waiver. So communication is required. So the key points there, guys, with respect to waiver or consent, that defensive waiver or consent, is that it's found within the legislation. Where it's found, it's a full defense, and there must be communication between the parties before it can operate as a defense. All right. Now, I just want to check something here with you folks. Okay. Yeah. Okay. Now, guys, your questions that are on Moodle, just before I move on with the defenses, your questions that are on Moodle, your questions for class, that booklet that's on Moodle, your business law Moodle page, see this question booklet, questions for class. So I'm going to share that document with you now, and for the next few minutes, it's a very quick quiz. I want you to look at page 9 and page 10. Okay, so it'll probably take you 5 minutes to do it. So just for 5 minutes, I want you to look at that, and then we'll go through the answers together. Okay, so just for 5 minutes, I want you to have a look at that. Okay, so pages 9 and 10, the quiz, and I'm sharing it with you now, I understand. Yeah. Okay, so I'll continue to share it with you. Okay, and I will, if you don't have it handy, you'll see it here you'll see it here. But otherwise it's available on Moodle. I'm just going to launch a poll there to grab the attendance, guys. So please make sure that you vote to confirm that you've attended. Okay, guys, I'll start going through the answers with you here. Okay, so the law of tort concerns private wrongs, true or false? Okay, I'll start calling names, guys. Okay, so law of tort concerns private wrongs. True or false, Robin? Okay, true. Thanks, Robin. Okay, so you can unmute your mics, guys, if I call your names because I can't manage the chat as well. Contributory negligence can be relied on by the plaintiff in an action for negligence. True or false, Ciara? So Ciara Comerford?
True.
Read it again, Ciara. Can be relied on by the plaintiff. Is that true or false?
Oh, false. The defendant.
Yeah. Okay, just be careful. Okay, well done. A contract is necessary to sue in an action for tort. True or false, Jake?
False.
False. Good man. Well done. Okay. The main aim of tort law is to punish the victim. True or false, Louise? Is it to punish the victim? Louise Mengwe?
It's true.
Is to punish the victim in tort? No, to compensate the victim. So the answer there in number 4 would be false. Okay. And tort law falls within civil law. I look after this one, and that is true. Okay. Round 2. Question 1. One remedy that can be awarded in a tort action is an injunction. Name another. Sinead? Sinead Harrington? Would you be able to give us the name of another remedy that can be awarded in tort? Can you hear us, Sinead? Okay, that would be damages. The plaintiff must prove a breach of duty to succeed in an action for negligence. True or false, Cole?
True.
Good, well done, thank you. A doctor does not owe a patient a duty of care as there's no proximity between the parties. Fiona, true or false? Fiona, can you hear us, Fiona? Okay, Rachel, do you want to take this one?
False.
Good, well done. The case of Donoghue and Stevenson established the neighbour principle and formulated the duty of care. Nicola, true or false? Nicola, can you hear us?
True.
True, super, well done. And in an action for negligence, the burden of proof rests upon the defendant. Burden of proof, does it rest upon the defendant? Ian, true or false? Action for negligence?
False.
False, good man, well done, fantastic. Thanks, Ian. Round 3, the Caparo case looks at proximity. What else does it look at? It looks at reasonable foreseeability and whether it's fair, just and reasonable to impose a duty of care. The second one, the case of Donoghue and Stevenson followed the reasoning in Caparo. That would be false. Okay. Ireland has adopted the principles of Caparo. Name the case: Glencar and Mayo Corporation or Mayo County Council. And number 4, in assessing the standard of care, the court may consider various factors such as the probability of the incident and the gravity of the threatened injury. Name the other 2. They are the social utility of the action and the cost of eliminating the risk. And number 5, the but-for test can be used to determine causation. True or false, Gabriel?
True.
Good. Well done. Thanks, Gabriel. Round 4. In an action for negligence, the burden always bears the burden of proof. True or false? In an action for negligence, the defendant always bears the burden of proof. True or false? That is false. Okay. A negligence action is always commenced by the defendant. Again, that is false. Okay. The standard of proof in a negligence action is on the balance of probabilities. Mafal, standard of proof in a negligence action is on the balance of probabilities. Is that true or false? Okay, it is true. In a negligence action, the plaintiff must prove that the defendant owed him or her a duty of care. True or false? And that is absolutely true. Number 5, in a negligence action, it's not possible to recover damages. That is false. Okay, round 5. In a negligence action, the plaintiff can rely on the defense of contributory negligence to demonstrate that the defendant is liable. Okay, true or false, Kira? So round 5, question 1, Kira. Okay. Adam, round 1, question 5. Okay, Jennifer.
True.
No, it's be false. If you read it correctly, Jennifer, it says there the plaintiff can rely on the defense. So it'll be always be the defendant that'll be relying on the defense. So that the answer there in question 1, round 5 is false. The Constitution of Ireland outlines the defence of contributory negligence, and that is false. In a negligence action where a defence has been successfully proven, the courts can apportion the level of damages. That is true. Failure to wear a seatbelt is an example of contributory negligence. True or false, Shauna? Shauna Corrig? Question 4 in round 5. Okay, Sean, failure to wear a seatbelt is an example of contributory negligence. True or false?
True.
True. Good man. Thanks, Sean. Communication between parties is necessary before a plaintiff will be regarded as having waived their rights. True or false, Lauren? Does there need to be communication between the parties before a plaintiff will be regarded as having waived their rights? Okay, the answer will be true. Around 6, a jury will hear a negligence case that's false. The plaintiff must prove the defendant owed him or her a duty of care in a tort case. David, true or false?
True, is it?
True, good man. Yep. Ireland is a common law jurisdiction. That's true. The Constitution of Ireland provides that the sole and exclusive lawmaking powers are vested in the office of the DPP. That is so false. And the Oireachtas is permitted to delegate some of its lawmaking powers. The answer to that is true. Okay, round 7. Civil law actions are commenced by the DPP. Sinead Harrington?
False.
Good. Okay. Employment law is a branch of civil law. Joseph Dowding, employment law is a branch of civil law. True or false?
Would it be true?
It is, absolutely. Good man. Well done. The standard of proof in a criminal trial is proof beyond all reasonable doubt. Is that true or false? Sherar Masood?
Adi, my name is, you can call me, I'm Sherry, but you can call me Sherry for short. Sherry is my short
Okay,
name.
I will. Okay. So standard of proof in a criminal trial is proof beyond all reasonable doubt. True or false?
True.
True. Good man. Well done. District court is the lowest court in the court hierarchy. That's true. Community service orders are awarded in negligence actions. No, they're not. And that is false. So round 8. The law of the European Union is a source of law in Ireland. That's true. The Civil Liability Act 1961 is an example of legislation and is a source of law. True. In a criminal law action, if the defendant is held responsible, the court finds that he or she is guilty of an offence. That's true. Theft is an example of a criminal law offence. That's true. And an action in tort in criminal law could arise from one incident, and that's true. So I think it was all trues there in round 8. And as far as I can see then, that is all the questions there in that. So 8 5's 40. So 40 questions there, guys. So hope you did well. Is there any one of them you want me to go back over or to clarify, or is there any answer you missed in with regards to the questions there? Okay, so there's a few things coming up in the chat, guys. Would you just say them to me now, because I'm losing track of it. Okay, so what questions need clarifying? So Jennifer, what questions did you want me to clarify?
Round 4, question 3, was it? Oh no, I have round 4. So round 3, question 1 was one of them. I just missed
Round 3, question.
1.
Which one? The Caparo case looks at proximity, reasonable foreseeability, and whether it's fair, just, and reasonable to impose the duty of care. Was there any other one, Jennifer?
Round 5, question 3.
In a negligence action where a defence has been successfully proven, the courts can apportion the level of damages. That's true. They can. Okay.
That's all, thanks.
Okay, you're welcome. Was there anybody else there, ladies and gentlemen, that had a question that they wanted clarified? I think someone else put something in the chat. Is it Enoa? Which one was it, Enoa?
Yeah, round 2, question 2.
Okay, now just find the question. Round 2, question 2. The plaintiff must prove a breach of duty to succeed in an action for negligence. Yeah, true.
Okay, thank you.
You're welcome. Did anyone else want anything clarified? Okay. Right, folks, just going back here to the defences and tort. Just to note this one of necessity, this one isn't pleaded anymore. Okay, it would be very seldom that it would actually be pleaded, this defence, and this defence is where an act, you'd plead this defence where an act that would normally be described as tortious is carried out in circumstances where there's no alternative and is done with the intention of preventing a greater evil. Okay, we don't tend to use this one anymore. It's you wouldn't see it pleaded. You might see this defence of inevitable accident pleaded not too often, and the defendant in arguing this defence needs to show that no reasonable precaution would have prevented the occurrence of an accident. It was pleaded in this old case of Stanley and Powell. The defendant here fired his gun at a pheasant, but instead the bullet had ricocheted off a tree and injured the plaintiff. And as the act couldn't have been avoided by any reasonable precautions, the defendant was held to be completely blameless and not liable in negligence. So it was an inevitable accident there in Stanley and Powell. Okay, so the defence was successful when it was pleaded there in Stanley and Powell. The similar defence was pleaded in O'Brien and Parker. This involved the defendant losing control of his car, causing an accident with the plaintiff, and the plaintiff suffered loss and damages, and the plaintiff sued. Plaintiff sued for negligence and claiming a breach of duty. And the defendant raised the defence of inevitable accident. He argued that it was the accident was caused by the result of the sudden onset of epilepsy without any prior warning, and the court in principle accepted that. Okay, and similarly in Coonahan and Bus Clia, this involved plaintiffs here were husband and wife, and they were injured when a bus in Dublin the bus driver became unwell and crossed a number of lanes and mounted a footpath and caused injuries. And the bus driver suffered from latent heart conditions, which caused a blackout. And there was no preliminary warning of the condition or anything like that. But the High Court said that a driver always remains under duty to do their best to actually control a car, even in a difficult situation. And there was no evidence here that the driver had failed to do so. So it was an inevitable accident. And the last defence that can sometimes be pleaded is legal authority. It's where the defendant can argue that they were authorised by legislation to do so and that there'd be no liability. Okay, if they were authorised by legislation. And limitation of actions then, guys, you don't have forever to make a claim. A plaintiff has only 2 years to make a personal injury claim, 1 year for defamation, and other torts 6 years. After that, they're out of time. In other words, they're too late and they're called, what we say, they're statute barred. Okay, so they can't take a claim once a certain time limit has passed. The courts won't entertain your claim if you're too late in actually arriving to their door with the claim. So best advice is to make sure that the claim is taken in time. Okay, so to sum up then on the defences, guys, the most relevant ones in terms of that are pleaded are going to be the defence of contributory negligence and the defence of consent. Necessity, no. A little bit with inevitable accident and a little bit with the statutory legal authority. Okay, when someone claims that they were authorised by statute to do so. Okay, does anybody have any questions on that? On anything we've done there on the defences? Okay, so somebody asked me a question. Somebody asked me a question there earlier in the class about the case of Coffey and Kavanagh and how much or how the conclusion of the case was. Just to note that in that case, they made a finding in the case that there was a 25% contributory negligence on the part of the employee in the case of Coffey and Kavanagh. That Supreme Court decision. Okay. The reason the court found there was contributory negligence was that she was accustomed to working in the area. She was aware of the dangers and she had, mentioned about her work area previously. So the court found that she was contributory negligent. Okay, guys, does anybody else have any questions about anything we've done today? Is there anything you want me to clarify or to check back over? I think somebody put a message in the chat. Sherry, round 3, question 3. So round 3, question 3. Ireland has adopted the principles of Caparo. Name the case. The case would be Glencar and Mayo County Council. Would be the case which dealt with the adoption of the Caparo principles. All right. Okay, folks, I leave it there. So for today, in tomorrow's class, we will be moving on and we'll be start looking at contract law. So thanks for your attention, guys. Stay safe and look after yourself, and we'll see you all in class tomorrow. Thanks, guys. Okay, you're welcome. Thank you very much.